babeera mu kooti oza si kooti yeero
Kamera sini. Kamera sini mulio. Malizo kadi.
Asizeke mina.
Wana mtu. Bakusara. Yimbazi kuva ddi wakyusa kooti waiswanga eno gy'omuwuliza tulindidde eri wansi
bamuleta nerudi last time
nza nti nze oyo akyuse ekkooti oyo sebo oyo mubuuza encyclopedia kanasuulira leero mbalinga naye omutima gwonna nemudda nakawa
Mwategeera erinnya lyange tusobola kujja bundi
wano wonna waliwo
ate bano abakwata emondi
tetweyita mannya munaye ng'olina
kiba kyabulabe
oli ajja n'akuterako ekigundi ng'amanya kulimbaza yagajja
omwana wa boni baleseewo ye bona adduse kukola pepe kuddayo awo aseekala obadde omwana
kyangu nnyo omukulu lwagala mufulu
People power.
Here, eh?
I'm walking. Okay, it's fine.
We are moving. Uncle and
Bobby Wine is not a crime. I am not a criminal. This is persecution. And we will not stop, we will not, and we will not stop, we will not relent, we will be resilient, making sure that democracy overcomes violence. It is very unfortunate that violence is taking precedence over democracy, and it is upon all those sane in mind, all and sundry, to struggle for the liberation of this country. We will not stop, we will not be intimidated. You see, they have attacked the fourth estate, they have attacked the judiciary, they have attacked the legislature, and it is all in name of keeping the longevity of anarchy and dictatorship. I repeat, supporting Bobby Wine is not a crime. I am not a criminal, and I'm not on trial. It is my liberty that is on trial. It is my liberty that is on trial. I am not on trial.
That's so easy.
I am not a criminal. I am not on trial. It is my liberty on trial. This is political persecution. Many people are out there, criminals are out there, but working for the negativity of the system. I am not a criminal. Supporting Bobby Wine is not a crime. Bobby Wine is not a crime. Therefore, I am not a criminal. I just isolating us to gather us to representing the party that we live in. It is the idea, it is the generational mission that we are looking after, making sure that we liberate this country for our children and our children's children. I am not a criminal, and supporting Bobby Wine is not a crime. This is democracy of trial, the sanctity of the doctrine of separation of powers, the independence of the judiciary, the independence of the legislature. It is what is on trial, not Alex West on trial. It is the independence of the judiciary on trial. It is the sanctity of the doctrine of separation of powers on trial. It is not wasswa on trial. And we will fight until that is happening for our children and our children's children. What is on trial is my liberty. It is the liberty of all and sundry, of sane minds of this country, not Alex West. You have seen officers at the rank of SSP beating up people in supermarkets and being released in 2 days, and then people like wasswa cannot be released to go and do what they are supposed to do, to stand for the positions they are supposed to stand for. Ours is an idea. It is not criminality. We are using
Let us be orderly first. First listen. Let us take the order. do like this. Mugende one.
Sawa kukakana kwa wansi.
Nabaga nisohoka mu bwonko umurambo wawe ngatuteye bajya tufanya muziki
Kwanza ebu.
Criminal case number 572 of 2025, Uganda versus wasswa Alex Mufumbiro.
Appear in execution, so don't match my station. This part of the
Yes, may it please you, Your Honor. My name is Samuel. Appearing the Granite Council's account. Yes, the landed Sewalu Aran. Land Council.
So, Your Honor, just the counsel for the applicant was there. Last time we made an application. The purpose of calling the accused person, hearing the applicant to be admitted to bail. I prayed for an opportunity to make a reply to the application made. And in view of court, I'll be able to proceed. The applicant has a constitutional right to apply for bail. As enshrined under Article 23, 6A. However, it's a notorious fact, 6A. However, it's a notorious fact, both in law and fact and decided cases, that right of granting rests solely in the hands of court. And for those reasons, prosecution is here to object to the application and our objection will be founded under the Magistrates Court Act, Section 77. Your Honor, under Section 77 2A, court is implored that as and when it is determining a question of bail, court will, among others, consider and this consideration is not a suggestion. The wording of the section is shall. Shall consider among others the nature of accusation. That an applicant is charged with it. However, if you look at the charge sheet, the accused person is charged with the offense of incitement to commit a felony, whose aims incitement to commit an offense, whose aims is to have security personnel murdered. And to have security personnel murdered. Your Honor, this raises an issue which was of great public interest. As it may have the cause of raising advocate of great public interest, which might cause or is likely to cause anarchy, and is an affront to the peace and security of the general members of the public. Your Honor, the same is captured under guideline 13 1B. Of the Constitution-based guidelines for Court of Judicature Practice Directions 2020. The Constitution-based guidelines for Courts of Judicature Practice Direction 2022. That, read together with guideline 5E, which is to the effect that there is need by court, together with guideline 5, which reads that, which is paraphrased as the need by court to balance the rights of an applicant and the interest of justice in the consideration of bail by court. The question court should ask itself in regards to this is, will the interest of justice be served where security personnel charged security personnel are charged with the noble duty of keeping law, order, and the property of the general public. Yes, of protecting the lives and property of the general public. Feel when their own lives are actually at risk. Their lives at risk of being exterminated. By the direct consequences of the applicant's actions. I will draw upon court to address its mind and be guided by Article 126. Which demands that courts exercise judicial power in the name of people. And we believe God will agree with us that the best interest of the people is to have peace and security. So on the second ground, our second ground is premised under section 77 2B of the Magistrates Court Act of 19. 77 subsection B. And this is in regards to the gravity of the offense charged. The gravity of the offense charged and the severity of the punishment which conviction will entail upon conviction. Your Honor, the accused person is under Section 21 of the Penal Code Act, Cap 128. Under Section 21 of the Penal Code Act, Cap 128, laws of Uganda. A plain reading of the particulars of the offense is that the incitement was for the purpose of achieving the ends of murder. Was for the ends of achieving murder. Your Honor, murder is an offense under Section 171 of the Penal Code Act.
Let's clear the record. You object. Murder before you is not murder. Your Honor, it would be.
And the section.
Yes, yes.
He is preempting the arguments for the merits
Yes.
of the case. So I don't know what you will present during the hearing of the main case.
Your Honor, I disagree with my learned colleagues. I have not in any way stated that the offense is murder. The record will bear me witness. I am demonstrating to court what Section 77 of the Magistrate Court directs court to do. Yes, Your Honor. And that's what I'm doing. And Your Honor, I need to demonstrate, I need the record to be clear. So I say the accused person is charged, the offense of murder, not him. I'm saying the accused person is charged with incitement under Section 21 and a reading of Section 1 of achieving murder, Your Honor. Yes, and Section 172 provides for the punishment of murder.
Well, again, we object. We object to this direction. This thing, yes, sir.
Your Honor, if court may allow me to finish the point. Yes. The punishment for murder is death. Section 21. Section 21 provides the punishment for the offense by which the accused person is charged with. By which the accused person will face in the event is convicted. Yes. And the section is saying that the person will be punished to a maximum of 10 years in the event that his actions lead to the other offense. That's where I was coming from. And that's why I'm going back to say that the gravity of this offense charge and the punishment being 10 years. I will pray that court will also pay attention to guideline 13, 1A of the practice directions I cited above, which is also to the effect in regards to the gravity of the offense. Our next ground for objection is under guideline 13. And that is, court, we need to determine the risk of giving the accused bail, given that he has other charges pending in courts of law. 13N. 13(1)(n). Whether there are any other charges pending against the applicant. Your Honor, it's our submission the applicant has other pending charges. As he was charged with the offense of unlawful drilling, at the Kawepe Chief Magistrate's Court, unlawful drilling. Provide Kawepe Chief Magistrate's Court, court case number 1363. 1363 of 2025. Yes, Your Honor, of 2025. And with a copy of the charge sheet. Your Honor, for the record, that this person is still on remand on those charges. Your Honor, is also our contention that the accused person, if released or admitted to bail, is likely to interfere with witnesses. Your Honor, without laboring into the merits of the case, it's our contention that the accused person has the means witnesses in these charges. It's our submission, therefore, that Your Honor, court will deny the applicant's application Your Honor, it's also our contention that there is a likelihood of the applicant to commit a similar offense. And it's because some of the platforms that were allegedly used in the commission of this offense are still within his control. Access control
Some of the platforms.
that were used in the commission of this offense are still within his control. Although while in incarceration, he does not have access to them. Your Honor, I will be laboring into the evidence which will be objected by that colleague.
That's your disregard. That's what he's going into.
Yeah, that's why I don't want to go there.
Let's proceed.
Yes. Your Honor, it is our contention, while currently he has no access, given that he's under custody, releasing him on bail will automatically grant him the access. Your Honor, it's our submission that you will agree with us, court will agree with us, that a case for the denial of bail has been made, and as we said, the matters of great public interest, which considered by this court as was held in the case of Obey Christopher, the case of Obey Christopher, and others, versus Uganda. High Court miscellaneous application number 45, 46, and 47. Yes, it was a consolidated application, Your Honor. 45, 46, and 47 of 2015. Yes, Your Honor. Which restates what we have just informed court, that the relevant paragraph is highlighted for courts. So, benefit. Your Honor, in the likely event that court considers the likely event that the court considers to admit the applicant on bail, we will pray that the sureties, together with the applicant, be bonded to terms stringent enough to compel them comply to court directions. And we'll also be praying that court, that's in the likelihood that it gives bail, to bar the applicant against interfering with witnesses, or sub judice in regards to this matter. We so pray.
Yes. The joinder, Your Honor, the state admitted the provisions of Article 23. Samuel is the state admit to the constitutional command under Article 23 that guarantees the right to apply for bail, the rationale in Article 23, Your Honor, is the guarantee to enjoyment of the right to liberty. As well as safeguarding against the abuse of court process. Your Honor, we submit that investigations are still ongoing. An indefinite time unknown to us. A time indefinite to us. In that regard, being a constitutional right, Your Honor, in the event that the state is doing now, in the event that the state chooses to oppose bail, the burden and duty to provide substantial cogent reason now shifts and lies on the state. Mere assertions mere assertions and conjecture by the prosecution. Assertions and conjecture by the prosecution from the bar without any iota of evidence would be insufficient to deny the applicant bail to submit, but that for all that state has stated from the bar and mere assertions that must be proved. Otherwise, they remain arguments that are not only speculative in character, and the proceedings of this court to submit that the character of that submission of the state is not sufficient to override a constitutional right. The state submitted under Article 23, Section 77, Guidelines 13, on the nature of the accusation and the need to balance the interest of the public. Your Honor, the state went ahead to invite you to protect, in inviting you to protect the people under Article 126 that exercise judicial power in the name of the people. We submit that is a misconception by the state that the people referred to was exclusive of the applicant before you. Under that article, the provision is inclusive of the person before you. And as we all know, the right of one person is not any less than the right of the many. That is why the law provides this honorable court with the discretion of this court has to balance both the rights of the applicant and the general public. And in so doing, this court is not enjoined to impose conditions which are fair and reasonable to ensure that an accused person attends court whenever required. That's the rationale behind that discretion. We therefore pray that you find the submissions of the state to be mere assertions which cannot remove the entitlement to bail. The gravity of the offense, again, I'll invite you, Your Honor, to look at criminal miscellaneous application number 204 of 2023. Kavuma Hassan. In this case, criminal miscellaneous application 204 2023. Miscellaneous application 204. Yes, High Court. In this matter, the applicant was charged with number 204. Of 2023, where the applicant was charged with 8 counts of aggravated robbery. You'll find that the Honorable Justice Mwata disregarded similar arguments on gravity of the offense for being mere arguments that would not override constitutional right. Arguments similar, that they are merely arguments which are speculative. The argument is for denial of a right to liberty. There needs to be some evidence. Bail should not be denied because the state does not want an applicant to be free. Especially where there is the constitutional command under Article 23. On witnesses, okay, your hand. Witnesses. Okay, counsel handle witnesses. Still on gravity, Your Honor, the offense before you is not murder. It's merely a felony. It's a misrepresentation to overstretch it to murder. Others will not be applying before you, Your Honor. And the allegations remain for what they are, especially where investigations are not complete. On the other offenses, these were not the antecedents envisaged under Section 77. Antecedents that would deny bail are in view of a conviction that the applicant has been convicted, or a similar finding by a competent court. Otherwise, still, they remain allegations. The submission, it's a misconception that on an ongoing trial in Kawempe, merely the basis for an ongoing trial in Kawempe, where actual investigations are also not complete, this court would deny bail. On incitement, we submit incitement is not a continuous tort, but upon release, the applicant would continue there is no conviction on his record on incitement, no evidence of incitement before you. Or on incitement or any such case that would now impeach character. We submit, Your Honor, that the state has miserably failed to provide reasons that will take away the applicant's right to liberty. And that there has not been any opposition to the sureties. We believe this honorable court there has not been any opposition to the sureties. Have not been objected to. We pray that you find them substantial. As a condition, as a conditional safeguard. To ensure that the accused person will return whenever required. The state has provided many authorities that we believe are distinguishable. My colleague will proceed. My much obliged. Case law.
Your Worship, without wasting time, Your Worship, basically, as they report to the authorities.
Let's be guided. I left a link, especially the one on interference. I did not touch this. And the case law. That's why I did not submit on case law, because particularly we have a number of authorities that he has relied on, which we need to distinguish. Yes, yes, complaints. We have interference. We are well guided. We are well guided. Interference. Much obliged. Much obliged. On interference with witnesses, no disclosures have been made. This issue has been handled in the matter of a job. The authority. Now we will need to supply it. We could not speculate his reply. That we can only print it in a few minutes. Ojok Caesar. Ojok Caesar. And many and 7 others, 8 others, versus Uganda. Yes, High Court miscellaneous application number 4. Number 4 of 2023. The ratio in this case was that the state cannot submit that doesn't have the machinery and capacity to protect witnesses, that the state cannot submit that it has no capacity to protect witnesses. Not agree. Yes. The law has safeguards that can protect witnesses. We shall supply that authority on the public interest. On the likelihood still of interfering with witnesses. Every case is handled on its own merits, Your Honor. So on the allegation that he is likely to interfere with witnesses, it is a general submission. No specific witness has been disclosed as of yet. It has not named any. No material has been placed before this honorable court to substantiate that assertion and allegation. The law is that such an allegation must be supported by concrete facts and not mere speculation. For emphasis, as submitted before, through our application, the applicant bound himself that he has no intention of interfering with the course of justice, and that he is prepared to abide. That he has no intention of interfering with the course of justice, and it's the reason, Your Honor, that he provided securities, and he's prepared to abide by any conditions that this court may deem fit to allay the fears of the state. Any and all conditions. Finally, on the allegation of public interest, as a ground to support continued detention, public interest is best served when justice is done. About justice, and when justice is done in accordance with the law. This is a court of law and facts that should not deny constitutional right to liberty. And keeping an applicant in custody indefinitely would not serve the ends of justice. It does not public interest. It's not in the interest of the public that courts detain accused persons pre-trial as against the constitutional presumption of innocence. It's not in public interest. Where a state that believes that someone is not guilty until proven otherwise, it's not in public interest. That the same is changed at the whims of the state. Presumption of innocence protects every citizen. The intention was to protect every citizen, including the applicant. That is what public interest is, Your Honor. The circumstances, as I close, the state's objections, as stated earlier, are wanting on evidence. They are not supported by law. Because that law, the balance of convenience, even in public interest, favors the applicant who is a candidate. Who is a candidate for Member of Parliament. Nakawa East constituency. Who would not abscond on allegations on a felony? That you abscond from being in parliament on allegations, any allegations of a felony. We pray that you exercise your discretion on that issue judiciously. And I believe our submission, the applicant's submission, that is willing to abide by any conditions this honorable court may impose, to ensure that he enjoys his public right and civic right to participate. Even that right will be curtailed. Court will be curtailing the civic right to participate in public affairs. It would be curtailing the right to liberty, which are all protected by the Constitution. We are most obliged. And the principles submitted on, we shall provide. We are going to provide authorities, Your Honor, for your attention. Now, Your Honor, on principles alone, this is just an addition. We believe this court is averse. Oh, no, notes. These are my notes. These are my notes. I know. Your Honor, it is in my 20 years of practice on bail that I'm using.
Some decisions are adopted, some
Yes.
you receive them.
Yes, yes. But that's why. Let's seek your leave. Let's seek your leave humbly. That my colleague that had given the liberty to provide the cases, at least puts them on record.
That is not to me. Yes, you can provide. So that shouldn't be right. Because we've done justice.
We are most obliged. We pray that they will be granted on lenient terms. We are most obliged.
Can we have the ruling is stood over to, it is now 35 minutes. Midday. Let's use those 25 minutes. Have the ruling.
Right. We'll stop now.
The man opened the bag and removed
Order.
My intention was just opening things, right?
And officers, I think if you had the other mandis, they can go back briefly, show draft.
What was the funny place? Is it your key?
The ruling is going to be delivered in 25 minutes from now. On here, we're gonna take a short one. Just a short one, shouting at you. This one exactly. So let's hold here. Just getting back. Really want to see myself.